Hi, I'm Caleb Corey, and this is my case brief over State of Utah versus Travis D. Timmerman, 2009, Utah 58, Supreme Court of Utah, September 4th. The citation number is 200800206. The substantive facts of the case. In the case, Mr. Timmerman is charged with a sexual assault. Mr. Timmerman objects to the information admitted from Mrs. Timmerman's witness account to the police and the same form submitted to a nurse. Mr. Timmerman made this objection based on spousal privilege not to testify and the spousal communication privilege because Mrs. Timmerman's accounts were outside of the court and she was not forced to testify. The spousal testimonial privilege does not apply. Since Mr. Timmerman is being accused of a crime, the spousal communication privilege is not afforded to him either. Procedural facts of the case. The lower court denied the motion to quash the bindover of Timmerman, and Timmerman appealed to the Supreme Court of Utah, which affirmed the decision to deny the motion. The lower court was, I could not find who ruled the lower court. The appellate court was ruled by Chief Justice Durham. Applicable laws questioned: the Sixth Amendment of the U.S. Constitution and Article 1, Section 12 of the Utah Constitution, testimonial privilege 502A, confidential communications between spouses privilege 78B-1-137. This is not applicable if one spouse is accused of a crime, which is in the case of Mr. Timmerman. The remedy sought by the plaintiff or appellant was that she used her spousal testimonial privilege not to testify. The defendant/appellee sought to quash the bindover to the appellate court. The issue is, in a case involving sexual assault, the court should determine that the Sixth Amendment of the U.S. Constitution and Article 1, Section 12 of the Utah Constitution have not been violated because the appeal does not apply to preliminary courts and the spousal communications privilege is not extended to Mr. Timmerman because he has been accused of a crime. Holding: what answer does the final decision maker give to the primary issue in the case? Yes or no? No. A law was not violated in the trial court's decision. 4. Reasoning: what reasons are presented in the case in support of the holding? 3 cases: Barber, Green, and Ritchie established Supreme Court precedent confining the Sixth Amendment Confrontation Clause to trial courts. 2. Spousal communications privilege codified in Utah Section 78B-1-137 and Rule 502B of the Utah Rules of Evidence protect confidential communications between spouses during their marriage. This is not applicable if one of the spouses is accused of a crime. Rule 5. Rule 5 is rule of law. This establishes that spousal communication is not extended if you are accused of a crime and that the Confrontation Clause and the Sixth Amendment does not apply to preliminary courts. And that is everything I have. Thank you.